Afternoon, ladies and gentlemen. I think we'll start off with the presentation. I'd like to welcome each and every one of you to this session on the Colombo Port City Economic Commission Act, which is a new sort of act and a new sort of area that has come into being with the filling of the port city area and being commission also being appointed now. So the areas of focus will basically be the outline of the port city law, which Mr. Riad Ameen will cover, the investment opportunities within the port city, the offshore banking business that they are envisaging to attract, nature of the business operations within the port city, exemptions and incentives regime that is in place will also be areas of the discussion. So how the discussion will go is Mr. Riad Ameen, who is an attorney at law, who is well versed in this port city law, will take us through the presentation first, and thereafter we will have Mr. Thulci Aluwihare, Assistant Managing Director of Czech Port City Colombo Private Limited, as a panelist, and Mr. Naomal Goonewardena, who's also an attorney at law, who will take us through the moderation after the presentation by Mr. Riad Ameen. Riad, over to you.
Good afternoon to all of you. I hope you're keeping safe. As you know, the Port City, the Colombo Port City Economic Commission Act, number 11 of 2021, was passed recently. The act is meant to enable investments within the port city area. There are similarities between this act and the other laws that grant incentives, like the BOI law, the Strategic Development Act, and so on. And there are differences. So the Port City Commission law, the Port City Commission Act, covers a wide-ranging areas. It's not meant to be only a statute that will give you exemptions from taxation. It's also supposed to enable you to do business with ease. So with that lens in mind, let me quickly take you through the act, and which will also capture some of the provisions regarding taxation as well. So the starting point for an introduction with regard to the act would be as to who can conduct a business within the port city limits. So there are multiple people who are allowed to operate within the port city. I will take you through the provisions that relate to them. First and foremost, no one can engage in a business within the port city unless you are an authorized person. An authorized person is a person who has to have a license issued by the Port City Economic Commission. In addition to a license, he must also have a certificate of registration. In addition, he must also enter into an agreement with the Port City Commission. So all three requirements have to be fulfilled in terms of Section 26 and Section 32 in order to enable an authorized person to engage in business. Unless you have all those three things in place, you can't be an authorized person engaging in business within the port city limit. Now, the authorized person is not immediately entitled to tax exemptions. In order to be entitled to tax exemption, you have to satisfy the requirements for another category. That is, you have to fall within the definition of a business of strategic importance. So I'll come to that later. This is simply the authorized person is simply a person who's empowered to do business within the port city limit. Merely by virtue of that entitlement doesn't give him exemptions from income tax laws. So the authorized person, in order to do business, has to first of all apply. That application has to be in the form set out in regulations. So regulations have to be framed in terms of the act, enabling a person to apply, enabling the person to obtain the license, and ultimately the Colombo Port City Economic Commission will decide as to whether that person should be authorized to perform to carry out business or not. If they decide to authorize the person to carry out business, they'll be given a license and a registration, and that will specify the type of business they can engage in the port city, and also the terms and conditions that will apply. Those will also be set out in the agreement that will be entered into in terms of Section 32. In addition, there is a requirement imposed by statute for an authorized person. An authorized person who's going to engage in business in the port city limit area can't engage in business with Sri Lankan rupees. He can't engage in business even with foreign currency reserves that are held in Sri Lanka. It has to engage in business with foreign currency. That foreign currency can't be taken as a loan from Sri Lanka, can't be taken from foreign currency accounts such as the RFC or the NRFC account or the other accounts that are permitted to be operated. Instead, the funds have to be sourced from abroad. You can take a loan from abroad, or it can be your own equity funds, but it has to be sourced from abroad. That's a requirement that is stipulated in the Act. The authorized person can therefore, within the port city limit, you can deal with business in foreign currency. That is expressly contemplated. The challenge would be when some part of the business has to be done in Sri Lankan rupees. I mean, that would typically, you can pay your employees in foreign currency, you are expected to earn in foreign currency, you're supposed to source your funds in foreign currency. Yeah, there is some challenge when it comes to currency services for which you receive money in Sri Lankan rupees. That has to be converted back into foreign currency. That requires regulations. So once again, until regulations are framed, the conditions under which, if you receive payment in Sri Lankan rupees, under which you can convert that into foreign currency, will have to be determined in terms of those regulations. So, to summarize, you can't engage business in the port city limit unless you are an authorized person. An authorized person is not someone who is immediately eligible for tax exemption. That is only applicable for business strategic importance. Even to be an authorized person, you still need a license registration. You would apply for it in the forms prescribed by regulations. The commission will decide whether to permit you or not to permit you. The criteria for granting a license is set out in Section 31. That is, it has to be something that is in the national interest or in the advancement of national economy. I think the threshold is a little too high for a business, merely for an authorized person, but that's a requirement in the Act. If you fulfill the requirement, the commission will issue you a license and registration. It will specify the businesses that you can engage in. And in addition, you have to have an agreement with the commission. There is also a restriction in the Act about engaging in business with a Sri Lankan company or resident. So in other words, if you are an authorized person engaged in business within the port city limit, that doesn't automatically give you a right to deal with Sri Lankans outside the port city limit, Sri Lankan individual or a company. To do so, you need to obtain permission from the Colombo Port City Economic Commission. The Colombo Port City Economic Commission will only approve the request once again, meeting the threshold of national interest or in the advancement of national economy. So if they feel that it passes that threshold, then they will give you approval to engage in that business. That approval will have to be subject to the terms and conditions that they will prescribe, that will have to be prescribed by regulations, which they will then stipulate to you when they grant the approval. So regulations will have to be framed for that. The commission will grant approval if they feel that your request to engage in business with a party outside the port city limit is going to be allowed. And it is only subject to those conditions that you can engage in business with Sri Lanka. So in a sense, the authorized person is expected to engage in business only within the port city limit. If they feel they need to go outside the port city limit, they need to obtain approval. That approval will only be granted in terms of regulations, and the commission will have to grant that approval in terms of those regulations and subject to the conditions that they may stipulate. And the commission itself will only grant the approval if it passes that difficult threshold of showing national interest or advancement of national economy. The challenge will be to show, you have to show that when you have to first get your license registration. You also pass a threshold when you are seeking approval to engage with business with someone outside the port city limits within the territory of Sri Lanka. Citizens are allowed to come into the port city limit and make use of the facilities and the services that are there. They can pay for services in Sri Lankan rupees, but as I mentioned earlier, conversion of the Sri Lankan rupees to back to foreign currency has to be in terms of regulations. So those regulations will have to be prescribed. The Sri Lankans, if they purchase goods at the time when they leave the port city limit, they'll have to pay a levy. That levy will also be prescribed by regulations. So until those regulations are framed, there will be issues in trying to implement that entitlement for the citizens. That's in summary the provisions that relate to an authorized person. I will now move on to the provisions that deal with the business of strategic importance, which is possibly the more important aspect of the matter, because it's only a business of strategic importance that will ultimately be entitled to obtain tax benefits. Now, the tax laws from which the business of strategic importance can gain exemptions are set out in the Act. They include the Inland Revenue Act, the VAT Act, the Finance Act, the Excise Special Provisions Law, the Customs Ordinance, Port and Airport Levy, commonly known as PAL, Sri Lanka Export Development Act, which is the statute that imposes cess. Then there is also exemption that can be granted from the laws applicable for betting, gaming, and casino. So there is some contemplation in the Act, including in the provision where regulations could be framed that casinos will be allowed. And that is the reason why these statutes are in the schedule. Betting and gaming levy can be exempted, entertainment tax ordinance can be exempted, and Casino Business Regulation Act 17 of 2010 can be exempted. In addition, the Foreign Exchange Act can be exempted. And there is also a provision, to exempt the Termination of Employment Workmen's Act, which I will refer to later on, that relates to retrenchment of employees. So the period for which you can grant this exemption is 40 years. So there is a wide range of statutes from which exemptions can be granted. The period is quite long, it's 40 years. And this exemption can only be given to a business of strategic importance. Now, not every business will constitute a business of strategic importance. There is an elaborate procedure set out in the Act in order to qualify as a business of strategic importance. First of all, there are requirements laid down in the Act itself. Those have to be fulfilled. If an entity does not objectively satisfy those requirements in the Act, then the recognition of that business as a business of strategic importance can be subject to judicial review in court. So therefore, it has to fulfill those requirements in the Act. So the requirements in the Act are quite broad, but they are not something that can be easily achieved. It has to be a business. The definition of strategic importance in Section 53, a business that is projected to ensure success of establishing the Colombo port city having regard to the national interest or in the advancement of national economy. So you find that phrase appearing all over the Act. So that is one of the requirements. That is, it's either in the national interest or in the advancement of national economy. The other is that it brings in economic and social benefit to the country. So these are the other is that is likely to change the landscape of Colombo port city. So that's more of a development-oriented provision. So it contemplates businesses that will have a huge economic impact on the country, hence because it uses the phrase national and country in certain places. In addition, there are certain categories of global or regional businesses that are allowed expressly if they satisfy certain requirements because of the strategic importance, inflow of foreign exchange, generation of employment, the knowledge. It will bring in the promotion of tourism, setting up of corporate headquarters and regional distribution operations. So if you fit in within that, if you can fit the business within the business of strategic importance definition, then you can apply to the Colombo Port City Economic Commission for grant of exemptions. The exemptions from these acts have to be granted in the manner prescribed by regulations. So separate regulations have to be framed for granting of exemptions. I'll come to that in a moment. It is similar to the BOI law. Even in terms of Section 17, the benefits that are granted under the BOI law have to be consistent with the regulations. So the same would apply to this act as well. There has to be separate regulations that will set out the grant of exemptions. In addition, in order to be a business of strategic importance, or to fulfill these requirements in the act, the commission has to be satisfied that that it's a business of strategic importance. After the commission is satisfied, the commission will then have to make a recommendation to either the president or the minister in charge of the subject, in case the subject is not under the president, for recognition as a business of strategic importance. If the president or the minister in charge of the subject is satisfied that it falls within that classification, then the president or the minister will have to submit a cabinet memorandum. The act, in fact, sets out certain essential requirements of a cabinet memorandum. So it's very elaborate. So you have to set out in the cabinet memorandum the rationale as to why you consider this business to be of strategic importance, the specific exemptions from the enactments that will be granted. So there are, out of these tax statutes, you have to identify which enactments the exemption from which will be exempted, and those exemptions have to be specified in the cabinet memorandum. The commencement date and the end date for the exemption with a cap of 40 years prescribed by the Act, and the name of the applicant has to specify. So it's a specific approval that has to be obtained by the commission through the president, ultimately from the cabinet. If the cabinet grants approval, then it's not simply a case of having the approval in place. That approval thereafter has to be published in the Gazette. And the Gazette has to more or less set out the same degree of information that was required to be set out in the cabinet memorandum. Once it is published, once it is approved by the cabinet, published in the Gazette, then it has to be tabled in Parliament for information. Separately, the benefits that will be granted for business strategic importance, the exemptions that will be granted have to be framed by regulations. So unlike the identification of a business strategic importance, regulations, once framed, have to be approved by Parliament. So that has to be in place, and this approval of this particular business as a business of strategic importance also has to be in place after following this elaborate procedure. Now, the challenge in having this elaborate procedure laid out is that there are multiple levels of approvals that are required from multiple people. And if any of those approvals don't meet the requirements in the Act or the regulations, those approvals can be subject to judicial review in the normal court. Judicial review in the sense of either a fundamental rights application or writ application in the Court of Appeal. So that risk is open. It can be something that can be taken up by a public interest litigant if they feel it's a matter of some sensitivity. It's possible that these things may happen. It has happened before, for example, like in the Waters Edge case and the Insurance Corporation. And there are people who might take up these matters. So that's a cautionary measure that must be kept in mind when, even if you opt in this approval, that there is still a risk of some litigation that could potentially happen. So there is the authorized person who will have to do business. Then there is the business of strategic importance, which is allowed to do business with tax exemptions in place. The menial work, I would call it in that way, because in the sense that in order to keep the port city functional, there are several services that are required. There is there is a garbage collection, gas, electricity, water, maintaining common areas, services for the residents, services for businesses. All the area of work is performed by another person, namely the estate manager. So the estate manager will have, and the estate manager will perform the role, and they will charge a fee, which they are allowed to charge under the Act. And in addition, they will also collect rates on behalf of the Commission. So there will be these three people who are permitted to operate within the Colombo port city. Now, one of the reasons why people would want to come to the Colombo port city and do business is this notion that they don't have to go through this cumbersome process of obtaining regulatory approvals from the multiple regulatory authorities that are there in Sri Lanka. So unlike the BOI law, unlike the Strategic Development Act, the Colombo Port City law goes the extra mile in order to try and make that part of the task easy. The Colombo Port City law identifies the Commission as a single window investment facilitator. And they are empowered to coordinate with all the regulatory authorities expressly by statute and obtain their concurrence for with regard to regulatory approval, and also implement them within the port city limits. The wording in the Act with regard to the role of the Colombo Port City Commission in the context of regulatory approval was subject to some comment by the Supreme Court having regard to the phraseology used in the bill. The Supreme Court ultimately settled on allowing the Commission to exercise its powers concurrently, leaving within the regulatory authority its scope of powers to decide whether a particular act should either be, a particular level activity should either be allowed or disallowed. So the net effect of the Supreme Court determination, the bill in its original form, the act in its present form, is that you still need all the approvals from regulatory authorities. The Commission will get them for you. You can still use the Commission as a single window investment facilitator, But the regulatory authorities still have the right either to permit or not to permit those approvals. The commission can't override the powers of all those regulators. So those regulators are still vested with the powers that they are given in terms of the statutes that are applicable to them. Those powers are not taken away by the Act. The commission acts as a facilitator, and it will use the powers that are given to it under the Act to facilitate obtaining that approval for the investor as quickly as possible. So this includes matters such as visas. I'll come to work visas in a moment, but there is provision in the Act to enable visas to be obtained with greater ease for the foreign investor. It also extends to various other approvals that need to be obtained from regulatory authorities, for which the commission doesn't have the power to suspend, to override those acts. The commission can also require those regulatory authorities to set up officers within the port city limit, so that the investor, if they want to communicate with them, would go directly to that particular office within the port city limit and obtain those approvals in the event that is required. So to that extent, the port city, in terms of getting regulatory approval, might be considerably more easier than going to those separate individual officers if you are establishing a business outside the port city limit. But you still need the approval of those regulatory authorities, and even if they have an office in the port city limit, they might still nevertheless refer some decisions back to their head office, which is outside the port city limit, and they may still refuse certain approvals if they don't want to give it, because the port city commission can't compel them to give the approval. And if that happens, then you are left with the customary remedy of either filing a writ application or fund remittance application against the regulator for not granting approval, or for suspending or taking some action having granted such approval. So that's about the facilitation role performed by the commission. Now the port city law has a very important interim provision, which is applicable for 5 years until all the infrastructure is set up within the port city. As you know, the infrastructure is partially set up, but it's not entirely set up, and it will take some time. And in that context, the Act has made a very important interim provision. That is, it allows a business to operate outside the port city limit, but for a limited period of 5 years from the date the Act was enacted. And that is in section 64. So even though you're operating outside the port city limit, you could still get the benefit of some of the provisions in the Act. But that is limited only for a window of 5 years, possibly leaving space for all the development activities on the within the port city limit to complete. So you don't so if you're dealing with an investor at this moment of time for the next 5 years, you can still use some of the provisions of the Port City Act for a benefit for an investor, although the infrastructure is not has not been completely set up and developed at the moment. But that's only applicable for 5 years. The other thorny issue about doing business in Sri Lanka are the labor laws. The Port City law tries to limit some of the provisions in the labor laws in a very unique way. One of the labor laws that are restricted that are expressly restricted is the Termination of Employment of Workmen's Act. As you know, the Termination of Employment of Workmen's Act is the provision that relates to retrenchment of employees. So, the retrenchment of employees for any business in Sri Lanka, you need to get the consent of the Commission on Labour. There is criteria prescribed in a gazette form that sets out the compensation that's payable. But in practice, in order to get the determination of the Commission on Labour, even within the parameters of that gazette, that specifies the quantum of compensation is payable will take you a long time. And sometimes if the approval is not given, then you still go to court against the Commission on Labour. So the Port City Commission law allows the Commission to override the act completely, which means that the employer within the Port City can retrench you without having to pay you that compensation under the act. Of course, the scope of the exemption will have to be decided after we see the regulations that are enacted. It's possible that whilst allowing the exemption from the act, the regulations may require an alternative obligation on the employer. So we mustn't assume that the act will be simply swept away. We must look at the regulations to see how it will be replaced. But the Commission is allowed, subject to the regulations being framed, to make alternative provisions or no provisions at all with regard to the act. The other aspect is about foreign labor force. Now, the Act Section 33 allows the Commission to recommend the grant of visa to the Immigration Department, but that is only applicable if it is in the national interest or in the advancement of national economy. That will not be an easy threshold for the Commission to meet for every type of employee. It's possible that if there is a business that's set up which brings in a large number of employees, it's possible that a public interest litigant may challenge the entitlement for the Commission to recommend visa on the basis that you don't need to have all those employees permitted to work in Sri Lanka with those visa conditions, and that only some of them, employing some of them may satisfy the requirement of national interest or advancement of national economy. It's possible that some of those recommendations may not be captured in the radar, in which event it may not get challenged in court. But so long as it meets that threshold, the Commission can recommend the grant of visa for foreign personnel to be employed in Sri Lanka. Now, in the event they are employed in Sri Lanka, in terms of Section 35, they can be paid their remuneration in foreign currency. That will apply not only to foreigners, but even to locals. Locals employed in the Port City limit can also receive payment in foreign currency. So can the foreigners who are employed in the Port City limits. There is also an important tax exemption for employees working in the Port City limit. The locals who are employed there are exempted from income tax. The foreigners who are employed there, by foreigners I mean non-residents, they are exempted from income tax not only for the income that they earn within Sri Lanka, but also for income that they earn overseas. So their worldwide income and the income they earn in Sri Lanka is exempted from income tax. If you are a resident, the income that you earn from the port city is exempted. But of course, as you know, the income tax laws gives you other exemptions that you can utilize if you receive worldwide income. But the worldwide income is not exempted for residents who are working in the port city limit. Now, the port city law also makes a good attempt to deal with another area of law, labor law, that can sometimes be problematic. That is the ability to go to the labor tribunal. Now, as I mentioned earlier, the Termination of Employment of Workmen's Act can be overridden by the Commission in terms of regulations that may be made. In addition, there is a provision in the Act for arbitration. That's in Section 62. Arbitration between the employer and the employee within the port city limits. So the effect of arbitration of disputes between the employer and the employee is that if there is a termination, arbitration will be the remedy. If there is arbitration as prescribed by the Act, it's likely the labor tribunal will not assume jurisdiction. It doesn't oust the labor tribunal jurisdiction, but there are provisions in the Industrial Dispute Act that prevent the labor tribunal from getting into a matter if it's pending in another forum. So that provision might likely to be used in the event there is a dispute that crops up between the employee, in the event there's a termination and the employee decides to go to the labor tribunal, the employee will possibly object to the labor tribunal exercising jurisdiction on the basis that arbitration is the proper forum for it. So to the extent that there is a dispute regarding termination, the arbitration procedure could be used. But it doesn't, the port city law does not override all the provisions in the labor laws. There are several other acts that are applicable to employees outside the port city limit, which will also apply to employees in the port city limit. For example, the EPF Act, the ETF Act, the gratuity. There are other statutes like the Shop and Officers Act that prescribes working hours, overtime, so on. Wages Board Ordinance, which prescribes working hours, overtime, and so on. Those provisions, those laws have not been set out in the schedule, and they can't be overwritten by the Commission. And to that extent, it's possible that those laws will still apply, which means that even if an employee does end up going for arbitration with an employer in terms of provisions in the port city law, it's possible that the employee may argue that some of the clauses in the contract between the employer and the employee are contrary to public policy because they are contrary to the Shop and Officers Act, and the Shop and Officers Act may prevail. So we have to see whether those arguments will be taken up, how the courts approach it, but it's possible these issues may crop up even if an employee has to go in for arbitration. There is also a provision in the Industrial Dispute Act for labor arbitration by the minister. The Industrial Dispute Act is also not listed in the port city law. It's not excluded. So it's possible that if there's industrial dispute, the employee may still have the option of using the procedure of industrial arbitration through the minister under the Industrial Dispute Act. So port city law does to some extent overcome some of the labor laws, but it doesn't completely override them. The Termination Employment Workmen's Act and possibly the termination provisions and the jurisdictional labor tribunal are the two features I think that are dealt with in respect of labor laws. The final point that I wish to refer to is the litigation risk. As I mentioned, the Act requires in several areas decisions to be made by the Colombo Port City Commission. The exemptions that are going to be granted by the Colombo Port City Commission have to be prescribed by regulations. In addition, there are also approvals that have to be granted by the Cabinet of Ministers and by the Colombo Port City Commission with regard to a business strategic importance. So all these decisions, the framing of regulations, the approvals that have to be granted, they are all decisions that can be challenged in court. Regulations, unlike an act, can be challenged in court. And the grounds of challenge for regulations are very wide. You can challenge it on the basis that the regulations are contrary to the Colombo Port City Commission law. You can challenge it on the basis it's contrary to another law. You can also challenge it on the basis it's contrary to the fundamental rights provisions. You can challenge it on the basis that the regulations themselves are unreasonable or that they are uncertain or vague. You can challenge it. There are certain specific principles for challenging delegated legislation. For example, if they impose a taxing provision without an express provision in the enabling law, you can challenge the regulations. So there are several grounds on which regulations can be challenged. We have seen in practice that regulations are often worded much wider than the permitted scope under the Act. So regulations have to be carefully crafted. If they are not, they can be challenged. The difficulty is if regulations are challenged, it will affect the legality of steps taken in terms of regulations. So regulations have to be carefully worded. We haven't seen all the regulations yet with regard to the Port City law. There is some scope for exercise of discretion by court in writ applications when it comes to challenge of regulations. If a regulation has been in place for a long period of time, court might use a discretion not to quash it. That's under English law. It's possible that the same approach might be taken by Sri Lankan court, but the discretion is not something that is easily predictable. So there is a element of litigation risk. Fundamental rights applications can also be filed against regulations, but there is a time limit of 1 month. The writ applications, in contrast, don't have a 1 month time limit, but it has to be done within reasonable time. But regulations can also be challenged in other methods. For example, if someone is prosecuted, they can argue that the regulations under which they're prosecuted is ultra vires. So that's taken as a defense in a prosecution. There is no time limit for that. Whenever you're prosecuted, you can take up an argument that the regulations are ultra vires. So subject to those limitations, the regulations can be relied upon. Preferably if the regulations have been in place for some time and they're not being contested and they are in place, and you have to still look at the provisions of the Act and make your own assessment as to whether the regulations can stand the test of litigation, particularly if the regulation covers areas which are not expressly permitted by the Act to be covered. So subject to those areas of concern, you can operate within the framework of regulations, but the risk of judicial review must always be kept in mind. Those are the areas that I was hoping to cover. If there's anything else, I'd be happy to answer any questions that you may have.
Thanks, Riad. Can you hear me?
I can hear you.
Yeah. Thanks, Riad. I think I was a bit late in joining. I had some technical difficulties in joining. I think just for by way of introduction, I think Riad Ameen is involved very specially in the higher courts in Sri Lanka, and he has an extensive practice in areas such as tax and customs and administrative law and industrial law, all of which I think are areas of interest or of prime importance in relation to the application of the Port City Commission Act. And I think we have had the benefit of hearing him out on those matters. I think, Riad, if you can wait on this presentation so that Thulci can also go through certain issues and certain parts, and then thereafter we can deal with any questions. Would that be okay by you?
Yes, Naomal, I'll be around.
Yeah. Okay. Thulci, are you on?
Yes. Hi, Naomal. How are you?
Hi, Thulci. So before starting off, I think Thulci is the Assistant Managing Director of the Colombo Port City CHC Colombo Port City Private Limited, which is the development company involved in the Port City. Thulci, prior to his assumption of this assignment, which he has been involved in for, I think, 3 to 4 years, right? So he has been there from, I think you would call it day one of the development of the Port City. So he knows the ins and outs of the Port City itself. Prior to that, he was a director in the consulting section of PricewaterhouseCoopers. So Thulci, I think, over to you, Thulci. I think initially, I think we'd just like to know, it's 3 months since the act has been passed. And I know very well that COVID and all that. Where are we now in relation to the commission, the infrastructure development, and things like that as well?
Yeah, hi. Thanks, Naomal, and thanks, Riad, for that detailed description of the Port City Economic Commission Act. Progress, let me kind of touch base on the infrastructure development side. Albeit with the COVID, we are progressing, albeit it's slow, but so as we speak now, close to 100 hectares of land is now ready for investment. Most of the internal infrastructure, utility, the roadways, the bridges, the landscape work is going as scheduled, and we hope to complete majority of them by mid next year. In fact, we were planning to have the marina area and the beach initially to be open for public before end of this month. But obviously due to COVID now, we just need to see how that spans out so that the Port City can be patronized by Sri Lankans. On the law Port City law progression side, yes, the commission was appointed. Obviously, we need to kind of leave certain amount of room for them to really understand what this project. I think they have gone through that process, and we have had many meetings with the commission. And I understand commission also has had many meetings with outside third parties, government agencies, other regulators, overseas, or chats with or discussion with some of the overseas parties as well. Next key milestones, I would say, is that Commission has is calling for applications for a Director General position, the CEO. I think that role is quite a vital, crucial role, and hopefully there'll be a lot of interest by international professionals, CEOs who had done this before. But it is quite important to have somebody who has been involved from the inception of setting up an SEC. So we hope, and I think the deadline was before end of August. So that's one of the next or key milestones. And second is setting up and drafting of the required regulations. I think Riad mentioned that in his presentation. The law is only an enabler for it to be operationalized. Further regulations are required. And I understand that the Commission has called for proposals from reputed international firms to assist them in setting up procedures, because the non-regulatory businesses will only require certain procedures. Criteria to be set out on the eligibility criteria and the administrative process in terms of operating. The regulatory business is what is a bit more complex. And as you would know, whatever the regulations draft under the Port City has to be in congruence with the regulations or the financial system within rest of Sri Lanka. And ideally, the objective is that it should not have any adverse impact to the stability of the financial system within rest of Sri Lanka. So that's a bit more complex, and I would imagine needs to be thought through, and a huge collaborative effort with the existing regulators would be required. So that's where we are at Naomal, and happy to take any questions from any participants.
Yeah, so I think just one more question on this. Thulci, now unlike the BOI, I think BOI, it was clearly understood that they were the only person who was responsible for marketing Sri Lanka in relation to foreign investment. Now, in the context of the Port City, obviously there will have to be a directed marketing campaign in order to be able to attract foreign businesses into the country. Now, in that context, is it only the Commission which is involved in that, or is the development company also actively involved in that process?
Yeah, so it has to be a combined effort, Naomal, simply because for us to, we have rights over 116 hectares of land, right? And for us to be able to really attract primary developers who will come and invest on the hardware side of things, we need to demonstrate to them that there is a pipeline of interest by various businesses to come and locate or expand or relocate to Port City. Now, creating that pipeline, we are also kind of actively speaking to some of these anchor tenants overseas to see, look, whether they would consider Port City as a location to do their business, at least to access the region. The advantage there is that because the Port City law is only a framework, and there is absolutely a lot of room to draw the required provisions driven by the response by the market on various sectors. I think it is important that we communicate this feedback to the Commission so that the Commission takes it on board in drafting some of these regulations. Promoting port city, whether for primary investors or secondary businesses, it is definitely, most definitely, has to be a collaborative effort, but we are still trying to really align ourselves in how we want to and how we should be doing that.
Questions are coming into the chat box and I will take those questions up. But once again, just one difference between the foreign direct investment, which we have seen up to now, and the port city is that the port city is almost entirely taking out the infrastructure development, which will come up. Eventually, on an ongoing basis, the port city is all about services. And services eventually is all about people, right? So I think, Thulci, from your point of view and your experience also in consulting and also the skill set which we have, right? Do you think that we also need to have a concentrated effort in order to be able to increase the skill levels so that when the hard infrastructure comes up, we are actually ready to be able to actually accommodate those types of businesses which might be interested in setting up in Sri Lanka? And if so, how do you think it should best be done?
Yeah, good question, Naomal. Definitely, I can tell you from what we are planning to do in Port City and the supply of the required skill levels, there is definitely a gap between the two. So we can look at it two ways. One is that because the Port City positioning is to really not to cater for Sri Lanka and to look at the region, and we expect certain amount of mobility. It is through expats and then diaspora who may given the opportunity to work for a similar multinational company with an ecosystem created wherever they are. Obviously, we think that they may look to return to Sri Lanka. The other point is that we are also going to be working with the Ministry of Skills Development and Vocational Training to really map out what would be this, because now although the Port City is a 25-year plan, we have a immediate short-term 5-year plan identified. And also we have some idea of what sort of a sectors that we might attract. So based on those conversations, we will have that dialogue with the government to try and see how we can really upskill some of our graduates coming out of the university system, and also some of our existing employees, to make sure that there is adequate supply once the Port City is operational. But my real take on this is, I think the know-how or the knowledge transfer will play a key role, where for some of these very senior lagging sectors, we expect some of these expatriate staff to take those positions and over time transfer knowledge.
Right, I think going back to Riad, I think this is one of those matters which I think the Port City Commission Act purposely actually evaded. That is namely professional services, right? So yeah, throughout the act, actually, even though professional services would normally have been considered to be an important component of a international zone, right? So do you think that there will be issues with regard to doctors? For example, they're talking about international hospital. Then there will obviously be engineers, there will be lawyers, there will be accountants, all of whom will be rendering professional services, yes, outside to offshore persons, but from within the Port City. Do you think that based on the current statutory framework which governs these professions, that there would be issues around it, or do you think it will be as envisaged in the port city. They didn't deal with it, but it's implicitly assumed that everything will be okay.
No, there will definitely be issues, Naomal. I mean, as you know, the legal profession, not everyone can practice the legal profession. So there is an old ordinance which is more than 100 years old that restricts the type of people who practice in the legal profession. But that said, the Bar Association has not been very assertive when it comes to foreign lawyers traveling to Sri Lanka when it comes to arbitrations. And that's the main type of dispute that is contemplated in the port city. There can be some debate as to whether they are allowed to participate in arbitrations, but we have allowed that to happen over a period of time. There have been arbitrations where for example, even the Attorney General has participated with foreign lawyers in Sri Lanka on construction arbitrations, where they have not really objected to their entitlement of foreign lawyers to take part in Sri Lanka in arbitrations. Foreign lawyers have traveled to Sri Lanka to negotiate contracts. I'm sure you would have been a part to many of those. And
yes.
The Bar Association has not really stepped in and told them they can't come into Sri Lanka, they should be given visa, they should be deported because they are here on tourist visa and so on. So I think it's better from a governance perspective to have the laws in place, particularly to have a look at some of these old laws that apply to the legal profession, to the if there are any to the accountancy profession, and if certainly the medical profession is governed by the Sri Lanka Medical Ordinance. There are provisions that stipulate as to in what circumstances doctors can allow to be allowed to practice medicine within the territory of Sri Lanka. Port City is a territory of Sri Lanka. That's clear from Supreme Court determination. So if they are going to, I don't think they will be given a free hand to walk in and practice the medical profession in Sri Lanka. So if there's a plan to establish a hospital within the port city, and they hope to have if they hope to have nurses and doctors or dentists, all these are regulated professions under the medical ordinance. So they need to look at carving out some sort of facilitation to enable those professionals to come in to cross territories and practice within the port city. For lawyers, in order to avoid an embarrassment down the line, even though the objection never really been taken, to avoid these issues popping up when it comes to foreign lawyers practicing in the territory of the port city, at least, one may need to have a look at the profession, consult the Bar Association, and make appropriate accommodations expressly so that in the middle of an arbitration, you don't all of a sudden find an objection being taken as their right to practice arbitration within the port city limit. Or to, all of a sudden, you don't take up an objection when they come across to Sri Lanka to negotiate a contract. We shouldn't allow such an embarrassment would be detrimental to our reputation. So I don't think we should allow that. We should have those old legislation sort of tidied up and to accommodate them. There was a question I saw in the Q&A about accountancy firms. I think one of the issues that I see in the Port Commission City law is that it deals extensively with the primary business, as Thulci put it. The primary business, which is going to be of strategic importance, which will get tax exemption. There is also a reference to an authorized business, which is not necessarily something that will get a tax exemption, but which is allowed to operate within the port city limit. Now, if there's a Sri Lankan audit firm that wants to set up an office within the port city limit, or if, for example, if Nithya Partners or Julius and Creasy, or if I want to set up my own chambers in the port city limit, that might debatably be construed as a business trying to operate within the port city limit. Employees, Sri Lankan resident employees, will have to work in the port city limit, but there will be also ancillary service providers who might have to operate within the port city limit. The port city, the law contemplates an authorized person who's also sort of like a business, but doesn't sort of cater to professionals. I think you may need to look at provisions, sections 26 and 27, and the commission may have to look at whether that provision adequately covers Sri Lankan service providers, professionals who, as a business, provide service, whether they will be allowed to operate in the port city limit. The way out would be for the port city limit businesses to come out of the port city and use their services and pay for them outside the port city limit. But if they were to establish in the port city limit, that might be a challenge.
Riad, can I just, Naomal, can I just add a comment?
Yes, definitely.
on that, obviously subject to the legal interpretation, because I was involved working more closely with the government during this drafting of the law. The two ways Sri Lankans can do or provide services, goods or services to port city. One is they can be a Sri Lankan company as they are now and provide services to port city, and that would be as a deemed export, because you will be paid in foreign currency and you will not be required to become an authorized person to provide any service within port city, goods or services. A second option is you as a Sri Lankan company, a professional or as you said, Nitya partner, they can register their business within port city. The moment you become an authorized person, you are only permitted to do business within port city and outside port city, but not with Sri Lanka. So you can do business in and from port city, excluding Sri Lanka, because the whole idea is that any authorized person, the basic requirement is that you need to demonstrate that you are doing offshore business, or you need to demonstrate you have foreign source of income. So if you become an authorized person, whether you are Sri Lankan or foreign company, there is some restriction for them to provide their services in Sri Lanka. Again, I think there is a provision in the law to say that with the special approval of the commission, even they will be permitted. I think that was included, say for instance, one of the objectives of the law is to attract headquarter businesses, regional headquarters to come and set up in Sri Lanka, right? So you cannot kind of allow that business and say you need to exclude Sri Lanka in that whole equation, or a regional distribution center. I think for those, the government or the commission will look at the overall objective of that business and permit those companies or authorized persons to do business in Sri Lanka. Otherwise, it's a bit more protective, because foreign lawyers can come and do business or provide services within port city or outside, but cannot compete or provide their services, accountants or anybody, or engineers within rest of Sri Lanka.
Right. So, okay, Thulci, I think there's some few very directed questions. First, I think, which is one of the most one of the most relevant is, if anybody has an investor who is interested in coming and investing in the port city, does that person contact you, or does that person contact the commission at the moment?
No, I think easiest is probably they can direct any investments to us. We can facilitate that, but final approval and all that obviously will have to come from the commission. So because we are at the moment proactively looking at monetizing the land we have. Government of Sri Lanka, for them to start marketing and monetizing, that is about another 3 years down the line. Until 2023 July, government land portion, which is about 62 hectares, they will not be able to develop. There is inherent provision, because we have already made an investment about 1.5 billion. There is a provision included in our financing agreement, saying that we should have what would I say, an early advantage to kind of market this.
Right. And there's also another question in the chat with regard to, what do you think are the viable businesses which will eventually set up in the port city?
So it is primarily only a services oriented sector, an area. We have kind of identified about 4 or 5 sectors that we think, considering the location and based on some of the soft market testing that we did. One is the maritime sector. Okay. Second is financial services, especially offshore banking. Then trading, just pure trading houses, trading businesses. And of course, tourism. is one of them. So these are the 4 or 5 key sectors that we feel that and overall the headquarters or regional distribution centers. We feel these are the 4 or 5 sectors that, and IT BPM, most important. Sorry, I forgot that. We have in fact partnered with the IT chamber /com to really try and drive demand FDIs in this sector.
Yeah, so in that connection, Thulci, now let's take the IT sector for example, which provides its services entirely to persons outside Sri Lanka. Now, in such a case, first phase will only result in just a relocation of existing businesses into the port city, just to get the benefit of whatever the concessions they have, including tax holidays, and also the fact that you'll be able to pay your employees in foreign currency and all that. Will it just result in just a relocation and not really new business actually coming in?
Yeah, I think it's a bit of both, because the thinking is that it has to be hopefully incremental new businesses, right? Because some of these large brands, Naomal, if you speak to the IT sector, certain pain points that they have can be addressed through the port city law, right? One of the concerns, pain points have been the employment regulation, which is hopefully, is much relaxed within port city. Second is the transaction cost, simply because the conversion from any designated foreign currency to Sri Lankan rupees and the other way around, they incur huge transaction cost to kind of locate or position Sri Lanka as a service delivery for the region. So some of those large brands have been shying away because of those limitations. So what we are planning to do is speak to some of these large brands, identify those pain points, and make sure through the port city regulations these can be addressed, so that these brands can be relocated to Sri Lanka.
Right, I think just a question to Riad also. Riad, I think you indicated very specially the regulation making powers and the fact that those regulations could also be challenged. But one of the features of these regulations are most of these regulations, very especially with regard to incentives, is going through quite a detailed process, right? It's going to cabinet, it's going to be laid before parliament, and therefore taking into account all that, don't you think that it has gone through a process which should make it unlikely that there would be any sort of judicial intervention?
The rates, the exemptions themselves will ultimately be a simple case of delegate legislation going to Parliament for approval. What goes up to the cabinet and for information of Parliament is only the identification of a particular strategic business, and that strategic business would then be given an exemption that is in place in terms of regulations. I mean, we have had the BOI regulations in place for quite some time. They haven't been challenged. So the possibility that these regulations tend to be challenged only if there is a willing public interest litigant who wants to take up this cause. It is unlikely that a business enterprise will challenge these regulations in that way. The probability of these, the probability of this reaching judicial review is not very high. And the probability of success, even if they go through judicial review, is possibly also not very high, as you indicated, because I mean, exemptions are largely matters of fiscal in nature. Courts will be slow to interfere with what type of businesses should receive what type of exemptions, particularly if the regulations have gone up to Parliament and have been approved. But the identification of a particular business's strategic investment business and the amount of exemptions that are being granted for the through the regulations for that particular business might get challenged if there is a perception that that is not in the national interest or national economy. So, for example, if there is a type of business which is service related, which there is a uproar in the public domain as to whether it should in fact receive those exemptions, and it gathers momentum, and ultimately even if it's approved by Parliament, it might be subject to some form of challenge because of the elaborate process that is involved. Eventually it's published in the Gazette, the information becomes public knowledge, and it's easy to challenge than, for example, a private investment that merely goes up for cabinet approval. It may not be easy to gain access to all these documents, but when there's a gazetted approval that's already in place, it might be easier to challenge, particularly if some information regarding it is in the public domain. But like I said, I don't think it'll be the exemptions per se that will be challenged, but it might be more of a case of applying those exemptions to a particular business, which in the public domain has received criticism.
Right, fine. So I think, Thulci, I think one of the questions which has come in the chat is about what is the position with regard to the setup of businesses outside the port city and the ability to get the concessions and all that which are provided for in the Port City Act, or the approvals which are provided for in the Port City Act. The question has been specifically asked in relation to an audit firm, for example, which wants to be outside the port city geographical area, but still be entitled to whatever the benefits are, right? So is it only limited to the 5 years, the first 5 years?
No, so first is that if you're an audit firm or any consulting company, in the first 5 years, although you'll be operating out of port city, you still have to go through the normal application process of becoming an AP, an authorized person. The moment you, as I said before, the moment you do that, you can only provide services within port city and outside port city, but excluding Sri Lanka, right? The moment you become an authorized person. The second option is you don't have to become an authorized person. You can be a PwC or a Nitya Partners registered under the laws of Sri Lanka as is now, and provide any service to a port city company. The restriction is the other way around. If you become an authorized person, you are restricted in providing any services to Sri Lanka. But Sri Lankan companies, SMEs can provide their goods or services to ports.
Yeah, so I think, in that regard, I think there are a couple of distinctions there. This concept of this indirect export in relation to goods, it was clearly understood that it was you need to be, if it's a garment manufacturing firm, then in such a case, you need to be making the buttons or whatever it is in order to qualify as an indirect exporter. But if I was rendering legal services or somebody was rendering accounting services to a company like that, that was not entitled to the benefits which were conferred on the exporter. So do you think the port city would be different to that rule? Because it's, for example, the service which is rendering, you are not doing the back office work actually of that port city company. If you were just doing the back office work, which in actual fact was just taken as is or with a few refinements and being sent outside, that's different. But if you are just rendering a service, for example, or audit firm doing the audit of a port city company, would that still be what you contemplate as an indirect exporter or indirect service?
Yeah, so the audit is because it's a bit of from a regulatory perspective, whether you have to become a chartered accountant under the accounting laws of Sri Lanka, or can you sign otherwise? I'm not too sure. So let me just take a service, Naomal, as an example, because whatever the service you provide to a company within port city, the area of authority of port city is identified as offshore, right? And when you invoice to a port city company, it is no different to you invoicing to a company located in Singapore or Dubai. You will be paid in foreign currency for supplying that services, and it will be considered as a deemed export. That's my understanding. So the thinking is that what we want is such similar companies to be relocated to port city, and there by doing so, now some of these large companies who will relocate to Singapore or relocate to Port City from Singapore, because there are significant cost advantage in Sri Lanka, right? They will have, all the professionals will have great opportunity to provide their services to some of these large companies, rather than them sitting here and trying to access Singapore or Dubai or Hong Kong.
I think Thulci, some subject to correction, Naomal, I think some of those provisions, the VAT provision, Section 71C and the corresponding Lending Act, they refer to, they use the phrase outside Sri Lanka. So the port city technically, in view of the Supreme Court determination, is a part of Sri Lanka. So some of those provisions, such as the VAT Act and the Inland Revenue laws, to the extent that they grant exemptions to inward remittances from outside Sri Lanka, they will not give a benefit to the service provider. I mean, because in addition to the requirement that the money must come in foreign currency form, they also have a requirement that it must come from outside Sri Lanka. So to that extent, there might be in certain cases a distinction between a Singaporean company who takes services and a company within the port city. I think there may have to be certain reciprocal amendments that have to be passed in the tax laws.
Yeah, that's it. I think Riad, on that, I think there's some, this Inland Revenue section is also now, I think, very widely worded. It says, I think, render services either within or outside Sri Lanka. And I think the only requirement is that the payment has to be received in foreign currency through some banking system. So in other words, it seems to be wide enough, I think, as long as the word which is used there, the words like rendered to a non-resident is not there, as long as that sort of wording is not there within the scope of the exemption or concession, I think you might still be entitled to some concession. Because if not, what will happen, Riad, is simply this. If, let's say, one of the big audit firms wants to do audits of the port city companies itself, right? Can they do it from wherever they are currently located and enjoy the same tax benefits? Or do they need to locate in the port city in order to get that benefit? And even if they locate within the port city, would they still be entitled to the benefit because it's being rendered to a port city company? So I suppose those would be the issues which would arise.
Locating within the port city is not an easy task, because quite apart from fitting into the definition of an authorized person, there is also a requirement that there is the capital has to be formed with fund in foreign currency and can't be sourced from Sri Lanka. So you can't even use your RFC and NRFC funds to become an authorized person. So you have to take it, you source it all the way from out of Sri Lanka. So it's not easy for a service provider to locate themselves. So I think the other option mentioned by Thulci is the more practical one, that is Nithya Partners remains where they are, but provide services to companies within port city, and the same with PwC Sri Lanka. But locating within the port city might not be an easy task. Particularly in view of the restriction as well, that you can't deal with Sri Lankans, but you can do it the other way around.
Yeah, but any of these companies who have an offshore account or FCBU account, and any balances in the FCBU account, I think they can utilize for any investment in Port City. Second is that ideally, when you think about it, if you're a secondary service provider, not a primary developer, all you need is your initial setup cost. And I don't think that will amount to a significant amount. The second point, I think you are right. I also had a point now. For instance, when you provide a service to another Sri Lankan company, in your service invoice, there will be a VAT component included. Now, obviously, the question is, Port City is considered an offshore jurisdiction and you will be invoicing in foreign currency. Would that invoice carry VAT? Yeah. Because the Inland Revenue Act 2017 is quite clear and wide, as Naomal said. Any foreign source of income is anyways currently being exempt from income tax, right? On the VAT tax, I'm not too familiar.
No, I was looking at the VAT tax. It says outside Sri Lanka to be consumed or utilized outside Sri Lanka. That's the zero rating provision. So you may still end up having to charge VAT, but you may be able to claim a benefit under the income tax.
Right. Yeah.
It's a free flow of funds in the port city companies. Is that correct? Subject to obviously anti-money laundering and those sort of issues.
Sorry, Naomal, I didn't get your question.
Yeah, with regard to foreign exchange, there's a question that the notion is that there will be a free flow of funds. That means there won't be any sort of restriction when it comes to companies which are operating within the port city. Is that the correct interpretation?
Ideally, for this to be successful, it has to be that. Simply because you're using this location to do business elsewhere. And any company which is registered as an authorized person is recognized as a non-resident company for tax purposes. So these are definitions given in the Port City Act. So these are non-resident companies dealing or transacting with non-resident companies. Obviously, it has to be on a much relaxed foreign exchange environment. But the moment those authorized persons deal with a company in Sri Lanka, then the regulation should kick in. So that's the idea.
Right. Yeah. So I think there is just another question on foreign exchange itself. So eventually, as a result of this intermediation sort of activities which will take place in the port city, other than the hard infrastructure, do you think that there will be a large inflow of foreign exchanges such into the country? Because it will be just in and out, right? Because these are all intermediation sort of businesses, like whether it be insurance, reinsurance, whatever.
Yeah, but you're right. So one time hardware or the infrastructure investment to build Port City according to a master plan is about $13.5 to $14 billion. But this is a one-time investment, right? I think what is more important is the recurring economic value add from these companies. From what an independent study done by a consulting firm, they kind of estimated that to be north of $11 billion annually. So the economic value add from these businesses can be quite large. It's no different to Singapore, right? Singapore is really a hub to do business, services business. And that is a kind of similar concept that ideally we should be looking at creating in Port City and creating that destination appeal for businesses to come and set up. And the multiplier effects, once some of these large brands come and set up in Port City, can be huge for rest of Sri Lanka, predominantly through the supply chain impact.
Right. There is just another fundamental question. Like, I think, for example, if there is a person who exports, let's say, fruits to Maldives or something like that, and now he's supplying those same items to, we'll first take the people in the port city who actually, like the foreigners and all that, who are living in the port city. Would that be like considered to be like an export, or how would that person be taxed?
I mean, look, if this person is exporting fruits to a company located in Maldives as against probably an F&B or a hotel located in port city, I think it will be deemed as an indirect export, because he will get paid. So from a tax perspective, it's no different. Whatever he is now taxed at a concessionary 14% on his export of goods. Similarly, when he supply his goods to port city, he'll be taxed at that 14% concessionary tax rate.
Right, on the basis he'll also be paid in foreign currency, right?
Right.
So even, for example, yeah, that's right. So, but people who do something like shopping within the port city will be paying in rupees, but there will be
Sri Lankans are permitted for all retail kind of activities. If anybody wants to kind of obtain a service, retail or convention center or the hospital, Sri Lankans are permitted to pay in LKR.
Right, I think, Riad, do you have any questions to Thulci as such? Because I think most of the questions in the chat have been actually dealt with regard to the operation of the port city itself.
There only one question. When it comes to all these professional organizations that will eventually have to operate within the port city, the professionals, other than the capacity of employees, whether they be foreign doctors, foreign lawyers, how are you going to overcome the regulatory requirements for them to work in Sri Lanka? Have you started the consultation process with, for example, the SLMC or the Bar Association, or have you thought of anything on that line?
Yeah.
It's a complicated process. The SLMC is very jealous. They don't really allow foreign doctors to operate in the territory of Sri Lanka.
Yeah, so I think that's what the Act studiously avoided dealing with the issue, and I think you're raising the issue now 3 months after.
No, I think, look, fundamentally, you cannot really have a foreign branded hospital and say foreign doctors cannot come and practice. I don't see a huge issue also, because this was done before through the BOI route, right? Based on your investment value, like the Apollo, which was set up before, foreign doctors and certain amount of foreign nurses were allowed to come and practice. So I think it will take a similar route, because the investment required to put up the hospital here is north of about 100 million, just construction cost, except for the land. So I think if
Yeah,
you take
it's $100 million, right? I think you need to
$100 million.
$100 million here.
Yes. So I guess it can take that route. In terms of the lawyers, legal professions, I don't know whether the local legal fraternity would be happy to say that anyway those lawyers will not be able to provide any service within Sri Lanka to a Sri Lankan company. So somewhat your profession is protected. Whether it's a good thing or bad thing.
I think Riad, I think these are matters on which the professional associations actually should have been proactive and said we want professional services to be actually included in the Port City Act, because these are anyway not, as you say, these are anyway not these are not activities. If there is a foreign law firm which comes here and then renders services to the region, that's not an activity which anyway was within the purview of the current work which we are doing, because we don't have a regional sort of business here. And I'm sure that it's the same with regard to accounting or architectural or engineering or whatever it is. So I think it's for the professionals to take the initiative and say, we want to be part of this. We want to learn and we want to be part of this, and we will go through the learning process and then maybe assume the jobs which are equivalent to what Thulci now assumes, assistant managing director of a large law firm, right, which operates worldwide, or some a substantial something, right, in a larger scope of things.
I think Naomal, it will create more opportunity, especially, right? Because
Yeah, and
let's
also I
assume-
think I don't know whether numerically it will create a lot of job opportunities. You know the numbers we had, right? In our store, numerically it might not make the difference, but at least it pushes up the bar. No,
No, that's
right?
true. I agree with you. I think it's a good thing. I'm all for opening it up, but I'm just wonder whether whether you have considered the legal aspects of the restrictions that are in place, because the port city law only suspends a few laws. It doesn't sort of make inroads into other laws. So you may have to keep that in mind. And if there is some approval that's required to be obtained, whether it's from the SLMC or whether it's under some other laws for various other businesses to operate or professions to operate, you may need to sort of give some thought to how you facilitate it.
Yeah, because we are now, let's assume one of the large brands is looking at relocating, right? First thing is they look, our auditors are Ernst & Young or KPMG in Singapore and London and whatever. Are they there? Good. Our lawyers are Clifford Chance or Alan O'Novery. I'm saying. So it has to come with the whole gamut.
It has to.
Otherwise, businesses won't just merely relocate to Port City unless the supporting environment and the professional services are there.
There is a question also about something like a warehousing operation or something like that, which actually physically might be outside, but maybe the main office might be within the port city. Would things like that be allowed?
Absolutely. So one of the, for instance, let's take the Hambantota port, right, which is an industrial zone or any other BOI zone. Although your manufacturing industry can be in Sri Lanka, your buying office or your trading office can be set up in Port City. Now, what most of these merchandise exporting companies, what they do is, although their manufacturing facility is in a BOI zone, they export to their own company in Singapore, Hong Kong, and then they on sell. So that Singapore, Hong Kong, Dubai, those companies now can be relocated to Port City.
Right. I think we have answered almost all the questions which are in the chat, right? And to that extent, I think we have covered a lot of ground. Yes, I think thank you very much, Riad, and thank you very much, Thulci, for everything what has been said here, because I think this was a session which was very interactive, and also it had post the Port City Commission Act itself. I think we dealt with a lot of issues which are necessary to be dealt with, thought through, and we need to be working on it, I think, within the next 3-4 years before the physical infrastructure comes up. If not, year 5 comes, physical infrastructure will be up, and we'll still be asking the question, can a foreign doctor come and practice in this hospital, brand new hospital which we have built, right? Or are we still asking that question amongst ourselves? Right? Is it permitted? Is it not permitted? What will the GMOA say? What will the SLMC say? Right? And all those things. I think there is a lot of thought and process to be gone through before the physical infrastructure comes up. And I think if that can be the takeaway from this session, I think we have, achieved our purpose. With regard to I think the points which are being made, I think as professionals, and I think there are a lot of professionals who are on this webinar, I think we would need a skill, we would need to improve our skills in order to be able to deal with the challenges and the types of businesses which would be, which would actually make a difference to the port city. Right, if there is going to be a differential sort of thing in the port city, which is going to be what is called high value addition, high knowledge addition sort of businesses to be set up in the port city, and we want to be part of it, I think we will need to be, right, I think not me, because I think we are now on the decline, right, but I think the younger generation would need to upskill themselves in order to be able to work there. I think the thing should be that, okay, I'm getting double what I'm paid outside. right? I'm being paid double in the port city, double, not 3-4 times, not 5 times. And I work 40 hours a week working in my normal place. I'll have to work 60. Simple as that, right? If you're not willing to do that when you're 25, right? I think you have not understood what is required in a sort of competitive international environment to which actually Sri Lankans are not exposed. I'm sad to say it, we are not exposed to a competitive environment, and as a result of which, we are like quite comfortable with the 40-hour week, the maybe the $1,000 which you take home, and whatever it is, right? So thank you very much for all the insights, and I think thank you to all the persons who are involved in organizing this event, the Faculty of Tax and the Institute of Chartered Accountants, and also for giving me the opportunity of chairing this very informative and educative session. Thank you.
Thank you. Thank you. Thank you. Bye.